I have watched the federal government reverse its legal positions before, not through public announcements, not through presidential directives, through amicus briefs filed in pending litigation that signal to courts how the executive branch now interprets constitutional questions it previously defended differently. And when the Department of Justice files a brief supporting the invalidation of state laws it once helped craft, the signal is unmistakable. The legal landscape is shifting beneath regulations that seemed permanent. In March 2026, the Department of Justice filed an amicus brief in Young v. Hawaii, a Ninth Circuit case challenging Hawaii's near-total prohibition on concealed carry permits. The brief, signed by the Solicitor General and supported by 30 state attorneys general, argued that Hawaii's regulatory framework violates the Second Amendment under the historical tradition test established in Bruen. The brief went further. It argued that any state law effectively prohibiting law-abiding citizens from carrying firearms in public for self-defense, regardless of the specific mechanism used to impose that prohibition, cannot survive constitutional scrutiny. This was not a narrow technical argument about Hawaii's specific statutory language. This was a comprehensive legal position asserting that concealed carry bans, as a category of regulation, lack historical foundation and therefore violate the Second Amendment. The implications extend far beyond Hawaii. If the Ninth Circuit adopts the reasoning in the DOJ brief, and if that decision is affirmed or allowed to stand by the Supreme Court, every state law that effectively prohibits public carry will face immediate constitutional challenge. And based on the historical analysis the DOJ provided, those challenges will likely succeed. The case itself involves George Young, a Hawaii resident who applied for concealed carry permits and was denied because he could not demonstrate the urgent need that Hawaii law requires. Hawaii operates under a framework where concealed carry permits are issued only in exceptional circumstances involving specific documented threats. Open carry is also prohibited in most public places. The combined effect is that ordinary law-abiding citizens in Hawaii have no legal mechanism to carry firearms in public for general self-defense purposes. They can own firearms, they can keep them in their homes, but they cannot bear them in public unless they face extraordinary threats that licensing officials deem sufficient. Young argued that this framework violates the Second Amendment's protection of the right to keep and bear arms. The district court agreed and issued a preliminary injunction. The Ninth Circuit reversed, holding that states have broad authority to regulate the manner of carrying firearms in public and that requiring permits for concealed carry does not violate the Second Amendment as long as some mechanism for obtaining a permit exists, even if that mechanism is highly restrictive. Young petitioned for Supreme Court review. The court has not yet decided whether to grant certiorari, but the case remains active in the Ninth Circuit, and that is where the DOJ filed its brief. The brief's central argument is historical. The DOJ conducted an extensive survey of colonial-era laws, founding generation statutes, and Reconstruction period regulations. The analysis found no tradition of completely prohibiting law-abiding citizens from carrying firearms in public for self-defense. Some jurisdictions prohibited concealed carry. Some required permits. Some restricted carry in specific sensitive locations, but none imposed a blanket prohibition that made it effectively impossible for ordinary citizens to carry arms in public under any circumstances. The DOJ brief distinguished between regulations that impose conditions on the manner of carry and regulations that prohibit carry entirely. A state can require permits as long as the permit system is shall issue, meaning any applicant who meets objective criteria receives a permit. A state can prohibit concealed carry as long as open carry is allowed. A state can prohibit open carry as long as concealed carry permits are available on a shall-issue basis, but a state cannot prohibit both concealed and open carry, or make permits so difficult to obtain that the right becomes theoretical rather than practical. Hawaii's system fails under this framework because it effectively prohibits all forms of public carry for ordinary citizens. Concealed carry requires demonstrating urgent need. Open carry is banned in most locations. The combination leaves law-abiding residents with no legal avenue to exercise their Second Amendment right to bear arms in public. The DOJ argues this is not a permissible regulation of the manner of carry. It is a prohibition of carry itself, disguised as a permitting scheme. The 30 states that joined the DOJ brief represent a geographically and politically diverse coalition. The list includes Texas, Florida, Ohio, Georgia, Indiana, Missouri, Tennessee, Alabama, Arkansas, Idaho, Kansas, Kentucky, Louisiana, Mississippi, Montana, Nebraska, North Dakota, Oklahoma, South Carolina, South Dakota, Utah, West Virginia, and Wyoming. Notably absent are states like California, New York, New Jersey, and Maryland that maintain restrictive carry laws. The coalition signals that a substantial majority of states now view Hawaii-style carry prohibitions as constitutionally indefensible. The brief's legal reasoning has implications that extend beyond Hawaii. 7 states currently operate permit systems that effectively prohibit most residents from obtaining concealed carry licenses. Hawaii is the most restrictive, but California, Maryland, Massachusetts, New Jersey, and New York all maintained may-issue systems before Bruen that gave licensing officials discretion to deny permits even to applicants with clean records and completed training. After Bruen, these states modified their systems to remove explicit good cause requirements, but they retain discretionary elements that allow officials to deny permits based on subjective assessments of character, need, or suitability. The DOJ brief argues that these modified systems still violate the Second Amendment if they operate in practice to deny permits to law-abiding applicants who meet objective criteria. The historical tradition supports objective requirements like background checks, training, and fees, but it does not support systems where officials retain discretion to deny permits based on their personal judgment about whether an applicant has demonstrated sufficient need or good character. If those discretionary elements result in denial rates that make carry effectively unavailable to ordinary citizens, the system is unconstitutional regardless of how the discretion is labeled. This reasoning targets not just Hawaii, but every state that maintains meaningful barriers to obtaining carry permits beyond objective qualifications. California issues permits at dramatically different rates depending on the county. Urban counties like Los Angeles and San Francisco approve less than 10% of applications. Rural counties approve over 90%. The DOJ brief suggests this geographic disparity indicates that the system is still operating as a may-issue regime where officials exercise discretion rather than applying uniform objective standards. If the Ninth Circuit accepts that reasoning, California's system becomes constitutionally vulnerable, even though the state technically converted to shall issue after Bruen. New York faced similar challenges after Bruen. The state passed the Concealed Carry Improvement Act, which eliminated the good cause requirement but added extensive training mandates, character references, social media review, and in-person interviews. The stated goal was to create objective criteria, but applicants report denial rates that suggest officials are still exercising discretion based on subjective assessments. If the DOJ's argument prevails, New York's system would need further modification to eliminate any discretionary elements that result in denials for applicants who meet the stated objective requirements. The brief also addresses sensitive places restrictions. After Bruen, several states responded by dramatically expanding the list of locations where carry is prohibited. New York banned carry in Times Square, all parks, public transportation, government buildings, places of worship, private property unless the owner posts explicit permission, and anywhere a special event permit has been issued. The cumulative effect is that permit holders have almost nowhere they can legally carry in urban areas. The DOJ brief argues that while historical tradition supports narrow location-specific restrictions in courthouses, legislative chambers, and polling places, it does not support blanket prohibitions covering vast swaths of public space. If carry is prohibited in so many locations that the permit becomes meaningless, the restrictions violate the Second Amendment, even if some technical right to carry exists. The timing of the DOJ brief is significant. The Solicitor General does not file amicus briefs in every case involving constitutional questions. The decision to intervene signals that the executive branch views the legal issue as important enough to warrant federal participation. And the substance of the brief signals a fundamental shift in how the federal government interprets the Second Amendment's scope. Previous administrations defended state carry restrictions as permissible regulations. This administration is arguing that categorical prohibitions on public carry violate the Constitution regardless of the state interest they serve. The Ninth Circuit has not yet ruled on whether to adopt the DOJ's reasoning, but the brief creates substantial pressure. When the federal government and 30 states all argue that a law is unconstitutional, courts take that consensus seriously. The Ninth Circuit could still uphold Hawaii's system by distinguishing it from the historical analysis the DOJ provided, or by finding that the restrictions serve compelling interests that override historical tradition. But Bruen explicitly rejected interest-balancing approaches, so that path is legally precarious. If the Ninth Circuit strikes down Hawaii's system and the Supreme Court declines to review the decision, the precedent becomes binding in the Ninth Circuit, which includes Alaska, Arizona, California, Hawaii, Idaho, Montana, Nevada, Oregon, and Washington. Every state in that circuit with restrictive carry laws would face immediate legal challenges, citing the Ninth Circuit precedent. California's county-by-county discretionary system would collapse. Hawaii's urgent need requirement would be invalidated. Oregon and Washington, which have been tightening carry restrictions, would need to reverse course, but the impact would extend beyond the Ninth Circuit. Other circuits would face similar cases, and plaintiffs in those cases would cite both the Ninth Circuit decision and the DOJ brief as persuasive authority. The Second Circuit, which covers New York, Connecticut, and Vermont, would face renewed challenges to New York's post-Bruen restrictions. The Fourth Circuit, covering Maryland, would face challenges to that state's discretionary elements. The First Circuit, covering Massachusetts, would confront similar litigation. The legal pressure would be comprehensive and coordinated. If multiple circuits reached the same conclusion that carry prohibitions violate the Second Amendment, the Supreme Court would face petitions asking it to resolve any remaining questions and establish a definitive national standard. The court has been relatively aggressive in taking Second Amendment cases since Bruen, suggesting it views this area as requiring continued clarification. A case presenting the question of whether states can effectively prohibit public carry would likely be granted certiorari, leading to oral arguments and a decision that would govern all 50 states. The alternative scenario is that the Ninth Circuit rejects the DOJ's reasoning and upholds Hawaii's system. In that case, the DOJ and the 30 supporting states would likely petition for Supreme Court review directly, asking the court to reverse the Ninth Circuit and establish that carry prohibitions are unconstitutional. That path leads to the same endpoint: Supreme Court review and a definitive ruling on whether the Second Amendment protects a right to carry firearms in public that states cannot effectively prohibit through permit systems. For gun owners, the practical implications depend on where they live and how quickly the litigation resolves. In states that already have constitutional carry or shall issue systems with minimal discretion, nothing changes. In states with restrictive systems like Hawaii, California, and New York, the timeline for change depends on how courts rule in pending cases. If the Ninth Circuit adopts the DOJ reasoning, changes could occur within 12 to 18 months. If the issue goes to the Supreme Court, resolution could take 2 to 3 years. For law enforcement, the shift creates operational challenges. Officers in restrictive states have been trained under frameworks where most civilians do not carry firearms in public. If those frameworks are invalidated and carry becomes more common, training protocols, use of force policies, and officer safety procedures will need adjustment. Departments will need guidance on how to interact with legally armed civilians during routine encounters, traffic stops, and investigations. The transition from environments where public carry is rare to environments where it is common requires substantial institutional adaptation. I have watched legal frameworks built over decades collapse when the federal government withdraws its defense and actively argues for their invalidation. The DOJ brief in Young v. Hawaii is not just a filing in one case. It is a declaration that the executive branch no longer views carry prohibitions as constitutionally defensible. And when the federal government takes that position, supported by 30 states representing over 150 million Americans, the trajectory becomes clear. The question is not whether restrictive carry laws will fall. The question is how quickly the litigation will proceed, and whether states will modify their laws proactively or wait for courts to invalidate them through judicial decisions. The era of may-issue discretionary systems ended with Bruen. The era of effectively prohibiting public carry is ending now.